There is a silent eviction notice being drafted right now in the administrative offices of the Department of Homeland Security, and it has nothing to do with criminals or border crossings. It is targeting the lawful permanent residents who think they are safe. If you have a green card in your wallet, specifically a conditional 2-year card, you are walking through a bureaucratic minefield in 2026 that has been rewired to detonate on minor technicalities. USCIS has quietly rolled out 5 critical enforcement measures for this fiscal year, and mistake number 5 is causing a wave of denials that is blindsiding families who have done everything right on paper. We are talking about the potential revocation of your legal status and the complete forfeiture of your future in America, all because the rules of engagement have shifted without a press conference. Welcome to Immigration News Desk, where we expose the operational reality of the immigration system beyond the headlines. I am here because the gap between what the law says and how it is being enforced has never been wider. Today, we are dissecting 5 devastating mistakes that could completely derail your green card application or status in 2026. This isn't theoretical. This is based on a pattern of denials we are seeing in real time. If you value your residency, you need to listen closely. Before we break down these traps, hit that subscribe button and turn on notifications. The algorithm buries this kind of serious content, but you cannot afford to miss it. And if you know anyone with a conditional green card, share this video with them immediately. It might be the only warning they get. To understand why this is happening, we have to look at the why behind the what. The U.S. immigration system is currently undergoing a massive digital transformation. For decades, immigration records were siloed. Your travel history was with Customs and Border Protection, CBP. Your green card file was with USCIS, and your visa application was with the State Department. These agencies didn't talk to each other efficiently. In 2026, that era is over. We have entered the age of interoperability. The Department of Homeland Security has integrated its databases, meaning that a red flag in one system instantly triggers an alert in another. This digital dragnet is designed to catch discrepancies that used to slip through the cracks, and it is catching honest people who simply made clerical errors or didn't understand the nuance of the law. Let's start with mistake number 1, the silent abandonment trap. This is critical for anyone who already has a green card. In the past, the government only really tracked your entries into the United States. If you came back in, you were resident. But starting in February 2026, the government has implemented an enhanced exit tracking system. They now have a complete granular picture of exactly how many days you spend outside the U.S. This matters because maintaining permanent residence is not just about having a valid card. It is about intent and physical presence. The law requires the U.S. to be your primary home. If you are spending 6 months or more abroad, maybe taking care of a sick parent or managing a business overseas, the algorithm flags you. When you go to renew your green card, Form I-90, or apply for citizenship, the officer will see a timeline of your life that you might not even remember accurately. If they see a pattern of living abroad and visiting America, they can accuse you of abandoning your residency. This shifts the burden of proof to you. You have to prove you didn't abandon your status, which requires showing ties to the U.S. like tax returns, property ownership, and bank accounts. If you can't, they can strip your card. The strategy here is defensive documentation. If you must be gone for more than 6 months, apply for a re-entry permit, Form I-131, before you leave. This document signals to the government that you intend to return, effectively freezing your residency status for up to 2 years. Without it, you are gambling with your future. Mistake number 2 involves the public charge trap on Form I-485. This form is the gateway to a green card, and the questions regarding public benefits have become a tripwire. The public charge rule is a historic concept dating back to the 1800s, designed to ensure immigrants can support themselves. But the definition of what constitutes a public charge has fluctuated wildly in recent years. In 2026, the scrutiny is on consistency. The form asks if you have received, are receiving, or will likely receive public benefits. Many applicants rush through this, checking no because they assume they haven't. but benefits can be broad. If you check no, but the government database shows you received a specific type of aid, even something you thought was allowed, you are caught in a lie. This is called material misrepresentation, and it is a permanent bar to immigration benefits. It is a nuclear option. Even worse is the financial documentation. You must prove you won't become a burden. If you submit outdated tax returns or vague employer letters, the officer has no choice but to deny you. The fix is rigorous honesty and over-documentation. Verify your own history before you sign that form. Mistake number 3 is the zero-tolerance policy on incomplete applications. In the old days, if you forgot to sign a page or left a box blank, a nice officer would send you a request for evidence, RFE, giving you a chance to fix it. Those days are gone. Under current policy guidance, USCIS has the authority to deny an incomplete application outright. No warning, no RFE, just a denial notice in the mail. This means you lose your filing fees, which have skyrocketed, and your place in line. If your underlying status expired while you were waiting, you could be placed in removal proceedings. This shift is about efficiency metrics. Denying a case is faster than issuing an RFE and waiting for a response. Officers are under pressure to clear backlogs, and incomplete is the easiest reason to clear a file off a desk. This is why DIY immigration is becoming dangerous. You need to triple-check every page. Use a checklist. Have a second set of eyes review it. Do not give them an administrative excuse to ruin your life. Mistake number 4 is underestimating the vetting lag. We are seeing significant delays for applicants from specific countries, roughly 35 nations, that are subject to enhanced security screening. This isn't always public knowledge. It's an internal risk profile. If you are from one of these countries, your background check goes through extra layers of intelligence agency review. This takes time, sometimes months or years longer than the posted processing times. The mistake people make is traveling internationally while this is pending. If you leave the US with a pending green card application, you generally need advance parole to return. But even with advance parole, re-entry is not guaranteed if your background check flags something while you are gone. We have seen people stranded abroad because a policy changed or a new security protocol was enacted while they were in the air. The rule of thumb in 2026 is, stay put. Do not leave the US until the plastic card is in your hand unless it is a life or death emergency. The risk of being locked out is simply too high. Now we arrive at the most critical danger zone. Mistake number 5, targeting conditional green card holders. If you married a US citizen and got your green card within 2 years of the marriage, you are a conditional resident. Your status expires in 2 years. To keep it, you must file Form I-751. This is where the carnage is happening. The I-751 is designed to catch marriage fraud. Ideally, you file jointly with your spouse. But if the marriage falls apart, which happens, you have to file for a waiver of the joint filing requirement. Here is the trap: filing under multiple waiver categories. There are 3 waivers: good faith marriage, divorce, abuse, and extreme hardship. Some applicants, trying to cover all their bases, check all 3 boxes. They think, I'll give them every reason to say yes. This is a fatal strategic error. Each waiver has a different legal standard. If you claim abuse but can't prove it to the rigorous standard of immigration law, police reports, medical records, that part gets denied. If you claim good faith marriage but the divorce isn't final yet, that part gets denied. If one part is denied, the officer can deny the whole petition, even if one of the other grounds might have worked. By muddying the waters, you force the officer to adjudicate 3 weak cases instead of 1 strong one. The specific divorce trap is catching thousands. To use the good faith marriage waiver, you must be divorced, not separated, not filing for divorce, finalized with a judge's signature. In 2026, USCIS has stopped being lenient on this. If you file the waiver while the divorce is still pending in family court, they will deny it. You have to time this perfectly. If your 2-year deadline is coming up and the divorce isn't done, you are in a tight spot. You may have to file late and ask for forgiveness or push the divorce court for speed. This requires legal strategy, not guessing. Furthermore, if you try to file for citizenship, naturalization, while your I-751 is still pending, a common tactic, you face the double denial. If your marriage has crumbled by the time of the citizenship interview, the officer can deny the citizenship and revoke the underlying green card in one stroke. You walk in hoping for a U.S. passport and walk out in deportation proceedings. You must be honest about the state of your marriage. If it's over, pivot to the waiver strategy immediately. Do not pretend it's still a happy union for the sake of paperwork. That is fraud, and it will be caught. The underlying theme here is that the immigration system has moved from an administrative service to an enforcement agency. The benefit of the doubt is gone. The burden of perfection is on you. This is why Immigration News Desk exists, to arm you with the tactical knowledge you need to survive this scrutiny. We are monitoring the policy memos and the denial trends so you don't become a statistic. If you found this deep dive valuable, you know what to do. Like, subscribe, and share. The landscape is shifting under our feet, and the only safety net is information. Stay vigilant, stay documented, and we will see you in the next briefing.